Hello everyone. Thank you for joining me for this webinar. As you know, my name is Sarah Walburn. I'm a partner here at Seacrest Wardle, and today we are going to be talking about provider suits, which I'm sure all of you have plenty of provider suits going on right now. It seems to be the new exploding business that a lot of plaintiffs' attorneys are getting into. So let's get started here. You can follow along with the PowerPoints. As you know, we have two primary sections of the No-Fault Act that are applicable for provider suits. Primarily, it's MCL 500, 3107, and 3157. Now, I have the statutes up here on the screen. 3107, of course, is the statute for the reasonable charges incurred for reasonably necessary products, services, and accommodation for the injured party's care, recovery, and rehabilitation. Of course, 3157 is about the charges. Provider can charge a reasonable amount for the products, the services, the accommodations that they render. Now, the charge cannot exceed the amount that the person or institution customarily charges for products, services, accommodations, so the issues are usually the reasonable amount, the customary amount, and reasonably necessary. Now, before we get into the two types of provider suits on the next slide here, I want to talk a minute about burden of proof. Now, the burden of proof is still on the provider. Sometimes, and particularly in adjuster depositions, and some of you may be familiar with this tactic, the provider will sometimes try to switch the burden of proof to the insurer. That's not the case. It's still the provider's burden of proof to prove that they are these charges are reasonable, these charges are customary, the benefits provided, the care provided, the treatment provided was reasonably necessary. So we have to be careful sometimes in the adjuster depositions that they're not trying to switch that burden of proof. Now, there's also no dollar limit on the amount of benefits, which you know. This isn't like workers' compensation where there's fee schedules. There's no dollar amount. It's unlimited. There's virtually no limits on the type of care that can be covered. Eventually, you get into the experimental care and medical marijuana or, pee stems, pee stimulators, things like that. But that's a topic for another day. All right, the next slide here, two types of provider suits. We have causation generally, and we have reasonable and customary. So as you can see, causation cases rely on the testimony of the treating doctor or doctors, and usually an IME doctor of ours. And the argument is that the treatment provided by the facility did not arise out of the ownership, operation, maintenance of a motor vehicle as a motor vehicle. This is what we most commonly see, these causation cases. These are the ones where usually we get the case in, there's already an IME, there was an IME denial, and the provider is coming back to the insurance company saying, no, we need to get these benefits paid because it was related to the accident. And then we have to prove that it wasn't related to the accident. There was a pre-existing condition that wasn't aggravated or caused, or aggravated or exacerbated by the accident. I also want to back up here a minute and talk about 3112. 531.12 states that no-fault benefits are payable to or for the benefit of an injured person. In 1992, the Michigan Insurance Commission issued the Insurance Bureau Bulletin 92-03, which suggested that a dispute regarding the reasonableness of a provider's charge was essentially a dispute between the provider and the insurance carrier. Thus, the insured or the patient must be held harmless. So then, we get into all the litigation in the 90s about whether there can be a direct action against an insurer by the provider, whether the insurer has a duty to defend and indemnify the insured in these sort of provider suits. That's where we get McGill versus Auto Association of Michigan, 207 Mich. App 402 back in 1994. Now, we have the other landmark cases like Lakeland Neurocare Centers versus State Farm, 250 Mich. App 35, 2002, which essentially reaffirms McGill, stating that there can be a direct action against the insurer, and that 3112 specifically contemplated the payment of benefits to someone other than the injured person as reflected by its inclusion of the phrase, quote, benefits are payable to or for the benefit of an injured person. Now we also get Regents of the University of Michigan versus State Farm, 250 Mich. App 719 in 2002 that says, yep, we got a direct claim against the insurer for benefits by the provider. And then the Michigan Court of Appeals also noted that although plaintiffs may have these derivative claims, they also have direct claims for the personal protection insurance benefits, and that was also out of Regents, and that was citing Munson Medical versus ACIA 218 Mich. App 375 back in 1996. So if a provider's action is considered derivative, that means that it derives from the injured person's right to collect benefits. This kind of brings us back to the point I mentioned earlier about the burden of proof. So this is why the provider's burden of proof is the same as in a regular PIP case where the insured or the claimant is suing the insurer directly, because the provider's suit is derivative of the injured person's right to collect benefits. All right, back to the slides. Sometimes I jump all over, my apologies. So we talked a little bit about the causation cases. Now we also have reasonable and customary cases. Now R&C cases arise, sometimes they're referred to as UNC, usual and customary as well. It just depends on who you're talking to. So R&C cases arise when the insurer's auditor reduces a charge based on its software program. So the argument is whether the science behind the software is accurate or there's a problem with the coding. There aren't as many of these cases as causation cases, primarily because they're kind of difficult. Sometimes the science and the math and the statistics are hard to understand. There are some plaintiffs, some firms that handle these exclusively. They have specific attorneys that only handle R&C, and they're going after all the insurers pretty hard. I know of some plaintiffs' attorneys who represent the providers that are suing on $800 reductions. So they are hitting these things hard, and we need to know who the auditor is. We need to know what the science is behind the reduction, and we'll talk a little bit more about R&C cases after I go through a little bit of the recent case law. Now, in the next slide is the rights of providers to bring direct lawsuits. Here we have the Lakeland NeuroCare Center's case, which I mentioned a little bit ago, where we have the specific contemplation of the payment of benefits to someone other than the injured person, because we have the benefits payable to or on behalf of the injured person. Here's the Regents of University of Michigan versus State Farm that I mentioned a few minutes ago, and you can read through that. Now the recent case law, next slide, Michigan Head and Spine Institute versus State Farm. Now this is the one that is super important to add some very specific language into your release so that you can bar any claims by a provider. Now in this case, the insured injured party executed an all-encompassing release of no-fault benefits. After signing the release, the insured began treating with Michigan Head and Spine, and apparently it was clear that the injuries were sustained in the accident, that this person was seeking this treatment for. Now, State Farm refused to reimburse the plaintiff his costs based on the release. The issue presented in the case was whether the insured's release barred the healthcare provider's claim for reimbursement for medical services rendered to the insured after the release was executed. The court examined the release and ruled that it was not ambiguous. It's noted that the release carved out an exception to bar future benefits at a specific facility, not specifically at the plaintiff's facility, Michigan Head and Spine Institute. The court set forth the provisions of the release, and similar language can be utilized in releases that are obtained pre-suit. The court went on to state that the quote on or behalf of or on behalf of language in the release is similar to the term, quote, or for the benefit of, quote, found in 3112. And that, of course, the court has recognized creates an independent cause of action for the healthcare providers. So the use of the phrase, or on behalf of in the release is indicative of the party's intent that the release include healthcare providers' claim for reimbursement. So a suggested way to prepare a release would be, for example, for sole consideration of the amount of blank dollars, the insured, the claimant, the plaintiff, however you want to word it, does hereby release and discharge defendant insurer from any and all claims and demands for no-fault insurance benefits of any kind whatsoever for any and all expenses incurred to date and/or which may be incurred at any time in the future by or on behalf of insured arising out of the accident, including any and all allowable expenses of any kind, blah, 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 et cetera, et cetera. So this case, Michigan Head and Spine Institute versus State Farm, allows us to create a release that will bar future claims or past claims by a provider. So make sure when you're doing your releases, especially if it's pre-suit, that you include that language or on behalf of in your release. That will bar these medical claims later on. And I personally have done that many times where I've had a provider call me up and say, can you grab this release from your insurer, see if it precludes our claims. I grabbed that release from my insurer, yep, transferred over, it definitely precludes his claims, and they don't even file suit. So sometimes it can be used even to prevent a suit from being filed at all, and there's no motion practice, which is nice because most of the providers recognize that this is good law and that they're going to have to just back off and figure out another way to get their bills paid. Next slide is USAA versus Rimby Park and Spectrum Health. Now, this case at the appellate court level was primarily about the attorney's fees. But the underlying case is really about intentional act. So let's talk just a minute about intentional acts, because I often get these provider cases where they involve a jumper. We just call them jumper cases. Somebody opens up the car door as they're driving and just jumps out of the car. So intentional act, you have to intend the act and the consequence, and that's where we always get hung up on. You can always prove that they intended the act. Obviously, somebody didn't push them out the door. It was an intentional act on the injured party's behalf to actually jump out of the car. He physically opened the door and jumped out. Easy to prove. The harder part to prove is the intending the consequence. So, you know, these sort of situations are difficult. If somebody leaves a suicide note or says, I'm going to kill myself, and dumps out the car, there you go. That's a little bit easier, but it's never that easy. For example, USAA versus Rimby Park. Reina Reyes was catastrophically injured. She's lucky she didn't sustain even worse injuries and die as a result of this accident. I believe the car was moving at 45, 55 miles an hour. So Reina was out at her birthday party and had been drinking, and she got into the car. She was a passenger with her boyfriend, I believe it was, and they were arguing, they were fighting. So Reina apparently had enough. She opened the door and she jumped out, sustaining catastrophic injuries. Now, she obviously intended to get out of the car. It was difficult to prove that she intended the act to injure herself, to kill herself, because she took her purse with her and she took her birthday presents and her cards with her. If somebody was intending to injure themselves, they probably would have left those things behind. So that, and then in addition to not being able to get some psych records through the course of discovery, kind of made it difficult to prove that intending the consequence part of this test. So at the end of the day, it was difficult to prove the intentional act, and USAA was forced to pay benefits. As an aside also, USAA filed this as a DEC action in order to have that subpoena power to investigate, to have those depositions done, to obtain medical records and such. So that's why the case is set up as a USAA versus Rimby Park and Spectrum Health, because it filed a DEC action. And I believe Spectrum Health actually intervened, if I'm not mistaken. So case goes up because of attorney's fees. USAA paid over $800,000 in allowable expenses. The Court of Appeals confirmed an award of attorney's fees to Rimby Park and to Spectrum Health, and they were a large amount, almost $150,000 just in attorney's fees. The Supreme Court reversed, holding that there was a legitimate question of factual uncertainty as to whether Raina Reyes suffered an accidental bodily injury. So at the end of the day, the Supreme Court said no attorney's fees. There was a factual uncertainty, and the injured party in Spectrum Health were not entitled to those attorney's fees. All right, Bronson versus auto owners. This is that wonderful case that allows us to discover the actual cost of surgical implants, such as screws, pins, things like that. In fact, I have found personally that demanding this information, filing the motion to compel that information, will almost always end in a settlement for a very low dollar amount. We send our standard request to produce in interrogatories, asking for a variety of the normal things, including the cost of the plate, the screw, the P-stem, whatever the case may be. And then plaintiff, the provider, always objects, and then we file our motion to compel. I have won these motions to compel time and time again. And then once we get that order, bang, provider wants to settle, for half the charges, for a third of the charges, for a quarter of the charges, whatever the case may be. So this is a good litigation tool to get a very reasonable, favorable settlement. AOPP, I threw this in. It's an important case. We're entitled to review the medical provider charges. We have a right to review the medical bills for reasonableness under 3107 and 3157. It's a 2005 case, still is super important even today. St. Francis Hospital, Supreme Court denied the request to consider whether AOPP's holding stands for the proposition that any medical bill audit, regardless of methodology, constitutes a bona fide factual uncertainty, precluding the award of attorney's fees. So they refused that request. We were hopeful, the insurers, we were all hopeful that they would indicate that, yes, that is a bona fide factual uncertainty precluding attorney fees, but they refused that request. So at this point, we need to go forward and continue defending these like we always have. Now we get into Moody versus homeowners, 304 Mich. App 415. This is a 2014 case. In Moody, the issue was about the amount in controversy. We had the plaintiff's suit in circuit court. And of course, as always, the plaintiff, the injured party, the claimant, was asking for damages above the $25,000 jurisdictional limit. Several providers had jurisdictional limits and jurisdictional demands that were less than the $25,000. The court held that the provider's claims had to be aggregated into the plaintiff's claims, the injured party's claims. Now, courts are seeing this differently. Everybody's filing these Moody motions now. We all call them Moody motions in district court, forcing the provider suit up to the circuit court PIP suit. Almost inevitably, particularly in 36th District, I found in Detroit, I walk into a pretrial conference, and the first question out of the judge's mouth is there a PIP suit in circuit court with respect to this claimant? And if I say yes, then it's automatically pushed into that circuit court. These district courts are trying to get rid of these cases. A lot of these courts don't like these cases, so they are happy with this Moody decision and want to push these into the circuit court. And of course, it's easier to litigate all of these matters into one case because you don't want to litigate a district court case and a circuit court case and have two different outcomes. That's inefficient. And quite honestly, it's ridiculous. You have two different outcomes, possibly just based upon which court you're in. So usually we get that question when we walk into the pretrial conference. Is there a PIP suit in circuit court? Yes, Your Honor, there is. Fine, we are going to force this up into circuit court. Other times we do the Moody motion. Judge, there's a PIP suit in circuit court. Under Moody, this should be pushed into circuit court. We should be forced to intervene. I've only had one judge deny this motion. It was the most bizarre thing. It was his last day on the bench, and he denied my motion, and then he left the bench forever. So I don't know why, but we ended up having to litigate in district court while we were also litigating in circuit court on the same issue. Now, if these are filed in different circuits, so the district court provider suit is filed in Oakland County, but the PIP suit is filed in Wayne County, we can't force that intervention there. We just have to seek voluntary intervention or continue litigating in separate district or separate courts. The next slide is Wyoming Chiropractic versus Auto Owners. That was released December 9th, 2014. It has been approved for publication. Wyoming Chiropractic tells us nothing new. It basically reaffirms that a healthcare provider can bring a cause of action to recover PIP benefits directly. These suits were authorized by 3112 and advances the public policy goals of the No Fault Act. Again, nothing new, just reaffirmed it. All right, this is just something that has come up in my practice over the past year. So I've decided to throw it in there just as a kind of a talking point, something to think about. Assigned claims. Do providers have a duty to investigate claims before applying to the Michigan Assigned Claims Plan, or formerly the MCCA? There isn't a lot of real definitive case law on this, so I found I was actually working with on a provider suit with a provider attorney, and this issue came up, and we talked it through. We both looked at the case law, and there really isn't a lot. MCL 531.72 provides that a person entitled to benefits may obtain benefits through an assigned claim plan when, quote, no personal protection insurance applicable to the injury can be identified. That can be identified implies that there has to be some action to find if there is other insurance. That's how I interpret it, and quite honestly, that's how the attorney that was representing the provider interpreted it as well. Despite the fact that the statute does not require investigation, it is well known that the MACP will refuse to assign a claim if adequate investigation is not completed. And that has happened time and time again. So when these suits come in by the MACP, an assigned insurer, we have to make sure there was adequate investigation. Now, if there is inadequate investigation, what are our remedies? I'm not really sure. I mean, it hasn't gotten to that point yet, because it usually stops at the MACP, and they usually deny it at that point. But what if it gets past the MACP and we get the case and we discover, you know what, they really didn't do anything to determine whether there was a higher priority insurer? So that's something that I think might develop in the future. I just wanted to throw it out there as kind of a, by the way type point. Priority disputes. Now, this one is kind of, I don't like priority disputes. Generally, it's better to pay and chase. If we get a case in by a provider and they sue both A insurance company and B insurance company, or they sue just A insurance company, but we find out that B insurance company should be paying, what do we do? Well, it depends on what your business strategy is. Usually what I like to do is pay the provider as soon as I can when I know it's a priority dispute. Usually if I catch that early on, when I get the claims file in, I say, this is a priority dispute. We already know who the insurer is, or we may not know, but we know it's a priority dispute. I have kind of side agreements with a lot of providers, attorneys, where if I find this early on, I can usually pay charges or below charges if there's any sort of audit or there's a co-finity agreement or whatever the case may be. Pay just the charges, no attorney's fees, no interest, but we hold the case, we keep the case going, but the provider just doesn't participate. Provider just kind of steps back, we have his release, we have them paid, and we do our necessary depositions so we can have that subpoena power. I depose whomever I need to depose to determine who the higher priority insurer is. But at the same time, we're not incurring attorney's fees and we're not incurring interest for the provider, making the provider participate in litigation. I find out who my higher priority insurer is, and I third party them in, or I just call them up and say, hey, this is what's going on. Usually we can get it resolved for less attorney's fees, less interest, and less payments to the provider, less attorney's fees for me if we do it this way. But again, it depends on your business strategy. Some insurers prefer that we keep the case going as normal. We don't pay the provider till we get the higher priority insurer in there, figure out priority, and resolve it all at the end. Just depends on your business strategy. Back to reasonable and customary suits, as I was mentioning before. We need to interview the insurer's auditor, whether it's an in-house or hired out auditor. I know some of my insurers have an in-house auditor. We get these R&C cases in. I need to talk to that auditor, somebody that has knowledge as to what the scientific basis of their database is and how they determine the reasonableness. We need to sometimes hire an expert auditor. Sometimes we need to determine how that auditor is paid. I don't think this auditor is around anymore, but a few years ago there was an auditor who was paid on a contingency basis based upon how much they cut for that insurer. That became an issue because obviously there's a huge bias there for them to slice these charges of the providers. So that becomes an issue. So we need to find out early on how the provider, or how the auditor is paid. The issues. Is there a coding problem? We might need a coding expert. CPTs, ICD-9s, utilizations, modifiers, unit issues, bundling. We need to determine whether that's the issue. Sometimes it's just a software issue. Is the science accurate? Where is the auditor obtaining the data? Is it a self-generating database? So every time a bill comes in for a claimant to be put through the system to determine reasonableness of the charges, is that bill then part of the new data? And then is there going to be a qualified expert to testify as to the software and as to the statistical basis for which they determine the reasonableness? We also need to determine how the charges are being evaluated. Excuse me. Are they comparing charges of like-sized providers in the same GeoZip? Are they comparing the charges of the provider to an average of that same provider's charges over a certain amount of years? We run into problems with that over here on the west side of the state and sometimes up north where we don't have a ton of providers. East side of the state, there's tons of hospitals and tons of MRI facilities. They're not as common over here or particularly up north. So if we have an MRI bill, for example, let's say we have an MRI bill from Spectrum Health. This is where we usually run into it. And for some reason, the auditor is comparing MRI bills over 3 years and averaging them, but come to find out they're averaging the past 3 years of Spectrum Health MRI bills as opposed to comparing those charges to Bronson, Borges, whatever the case may be. So that provider is saying, hey, you're cutting our bill based on an average of our own bills. That becomes a problem. So we need to make sure that the auditor is comparing the charges to like-sized providers in the same GeoZip. Another problem comes when we have maybe like Lakeland, which is a small hospital, and they're comparing the charges to Spectrum Health, or vice versa. Spectrum Health is a big facility, and they're comparing what Lakeland is charging. That becomes a problem too, because one's a trauma unit type hospital and the other one isn't. So we need to make sure those things are taken care of early on in the case so that we can work towards a resolution. Let's talk a minute real quick about fraud. The Bowery case is super important. It's a new case. It has been approved for publication, I believe. Basically, fraud in any aspect of the PIP claim voids the policy now, but we need that fraud language within that policy. Which almost every policy I've ever seen has fraud language in there. So Bowery, basically, there was attendant care provider forms submitted saying that claimant couldn't do A, B, and C during the month of October, needed help with that stuff. Well, there was video surveillance of the claimant doing A, B, and C in the month of October. So obviously that was fraud in the PIP claim, and the court was able to say, yep, you can void the entire policy, no PIP benefits. These are becoming the new motions to file, the Bowery motion. I have one up right now. A lot of courts are granting these, and I think they're going to be applicable in provider suits. If we can prove fraud, the provider is going to be out of luck. TBCI versus State Farm is a 2010 case that's kind of going hand in hand with Bowery. A finding of fraud is raised judicata as to all their other benefit claims. I think that's going to become really important in these provider suits. So we'll just see how that plays out and how it develops over time, but I personally plan on using both of those cases to preclude provider suits and any sort of claim that is fraudulent. Well, that's it for me for today. If you have any questions, I'd be happy to talk to you. My information is located on the contact information slide in the PowerPoint. I am in the Grand Rapids office. If you have any questions, again, please call me or email me, and thank you very much for your time.